I'm thrilled to present our guest, Philip Reid, an associate lawyer at the distinguished law firm Secco and Filas, LLP. Mr. Reid is an accomplished litigator in the personal injury group, passionately representing clients involved in motor vehicle accidents, construction site injuries, medical malpractice, false imprisonment, and a variety of complex claims. With an impressive career rooted in personal injury law, mass torts, and family law across New York and New Jersey, Philip Reid has gained extensive experience handling cases from the first client meeting throughout appellate advocacy. His commitment and expertise make him a powerful force for those seeking justice. Today, we'll get his insights into the evolving landscape of motor vehicle accident law, the challenges victims face, and his perspective on advocating for clients in complex, high-stakes cases. So thank you so much, Philip, for joining us on this Attorney Spotlight series. We are so excited to hear from you and learn from your expertise on motor vehicle accident lawsuits.
My pleasure. Thank you for having me. Happy to answer any questions you may have.
Thank you. Okay, so we'll jump right into it. The first question that I have is, what are the most common misconceptions people have when considering a motor vehicle accident lawsuit?
I think there's two. The first is the length of time that a lawsuit can take. The second is how much money they may or may not receive. Expectations need to be set ideally during the intake process with respect to those two questions to help down the line.
Okay, perfect.
Lots of cases settle quickly. Lots of cases take years. Some cases go to trial, and some cases get dismissed. So the client should be, or potential client should be, aware of all of the different potential outcomes. And with respect to how much money they're going to get, right, everybody thinks, oh, I knew someone that got $1 million and their pinky got fractured.
Okay.
Well, first of all, I'd like to see the medical records. I'd like to see the settlement, paperwork from that case, but set that aside.
Right.
One of the crucial things in motor vehicle accident cases is, to some extent, you are limited by the insurance policy of the tortious vehicle. And each state in the United States of America has different state minimums for what the insurance policy is. For example, I reside in New York. I'm admitted in New York. 90% of my practice is in New York. In New York, the state minimum for auto insurance is $25,000. That means everyone who's driving has to have insurance coverage of at least $25,000 if they commit a tort and someone sues them.
Okay.
I know, because I practice in New Jersey as well, I'm admitted in New Jersey as well. In New Jersey, it's $15,000, and it's the same in Pennsylvania. So you could potentially have severe injuries, but be limited to only, let's say, a $15,000 recovery, less the attorney getting attorney's fees and disbursements and whatnot.
Right.
So I would say those are the two things that people don't really understand when they first meet the lawyer, do the intake process.
Perfect. With that said, what recommendations do you have, for example, for agencies or centers that help with the initial part of that intake in order to set the right expectation?
Couple things. The first is, obviously, you want to figure out where you're suing, right, which state, and be aware of the law of that state. On intake, you may not have all the medical records, right? People can get surgery a year out, 2 years out. Things can change. They may not seemingly have any injuries up front, but then it turns out they have a fracture. Or they haven't gotten an image done yet. It's crucial to know the laws of the state and to realize, hey, client, this is what you're potentially looking at. There's no guarantee we can get your recovery. Do you understand? So that way, later on down the line, there's no misconceptions. Oh, I was told I was getting $1 million, because I've had that happen, right?
Right.
Lots of times on the attorney's end, you're dropped in, you're parachuted in 2-3 years down the line in a case, and the client's saying, oh, I thought I was getting 100,000 on this. And it's like, no, we'll be happy to take 50,000. Every intake is different. Clients need to be given good expectations. If you have an intake script or intake paperwork, you need to make sure that it reflects what the law is in that state.
That's perfect. Thank you so much. Very helpful. From your experience, what are the critical first steps an accident victim should take to protect their legal rights? Because I know that, in those first few moments, they're in shock, they might be injured. Even if they knew what they were supposed to do, they might have forgotten in that moment.
So I actually want to jump ahead a few moments or even a few days after the initial impact. In New York, the police do not necessarily issue police reports anymore. I'm talking about New York City specifically.
Right.
If you can't get a police report, if the police don't do one, New York State has something called an MV 104, which is where you can submit your own police report. Now, this is especially crucial because New York is also a no-fault state, as is New Jersey. What that means is you have to put your insurance company or the other side's insurance company on notice of the accident within 90 days in order to get medical benefits regardless of who is at fault. Those are some strict deadlines. And one of the other creatures of New York is this entity known as MVAC, Motor Vehicle Accident Indemnification Corporation. That's a New York entity that allows you to sue them for up to $25,000 if, and only if, these criteria are met. You don't have a car and you have no homeowner's insurance or car insurance of anyone in your house, and there is some type of police report or MV 104. So even if it's a hit and run, right, the other car flees the scene, make sure you call the police, put them on notice that it happened, try to get a written report from the police. In the event that they can't give you a report, do your own report. Now, backing up to when the incident first happens, ideally you need to make sure no matter what, you get their license and registration, and if nothing else, get a picture of their license plate, because any attorney can run a plate search and figure out who they are, what their insurance is.
Okay.
Lots of people have dash cams nowadays. Try to figure out maybe if they do. And there's pros and cons to speaking to the other driver, but certainly if they say something like, "I'm sorry, it's all my fault," that's admissible. And you want to make sure you're aware of that, and that they say that. You don't necessarily need that in writing, but if you can have them communicate that to you, it certainly doesn't hurt. So those are the things I would say. If you can get a picture of the license plate, that's crucial. And make sure, if you can, do a police report or an MV 104 or whatever the other state's equivalence to an MV 104 is.
Awesome. I've only been hit a few times from behind, thankfully nothing serious, but I drilled it into my head to get out of the car filming. And so the second I get out of my car, I'm already filming the damage, the other vehicle, the driver, the license plate, everything I can get. So you have it all on record. And as you say, if they actually admit fault, then you would have that proof immediately, and it would probably alleviate the process from the beginning. So our next question, and I think this might tie into maybe the first 2 points that you mentioned, but can you, if there's others beyond this, can you share some common mistakes that accident victims often make that negatively impact their case?
Yeah, the biggest one is not going to an attorney fast enough, frankly. Even if you're not injured so horrifically, you should still go to an attorney right away to preserve your rights, right? Your average person might not know about no fault. If they get hit by someone that flees, they might not be aware of MVAC in New York State, for instance. They might just think, I have no right of recovery. They may also not be aware of underinsurance or uninsured motorist coverage, which is insurance that they pay for on their own insurance, specifically for instances where someone hits them and runs, or the other vehicle hits them, is 100% at fault, but maybe only has $25,000 in coverage. People don't realize you're consumers, right? You purchase insurance policies for these specific instances. In most cases, you pay a bit more to get underinsured motorist coverage. Right. And I've seen cases where even though the clients have it, they just don't feel comfortable suing their own insurance company. So that's a discussion you have to have with the client or potential new client right away during the intake process. Who are we suing? Is there underinsurance coverage?
Right.
Obviously I can't speak to every state. You have to check the deadlines and statutory criteria for each state, but those deadlines come up quickly. And if you miss them, lots of the time there's ways to alleviate that, but you can't always. One of the other things I would just add really quickly along these lines is when you're suing a municipality, for example, say a municipality vehicle hits you in the rear.
Right.
There are very strict timelines to bring what's known as a notice of claim. That's what we call it in New York. You have to put them on notice utilizing a specific form that they approve. And in New York, that's within 90 days. In New Jersey, it's the same. Those 90 days can go by like that. And it's crucial you see a lawyer right away to protect your rights. So that's the biggest mistake I see people make, is simply not going to the lawyer fast enough.
Absolutely. And I think this is likely true for most contracts, but it wouldn't surprise me that people have uninsured or underinsured insurance and actually have no idea. Also because in many states they're required to have insurance, and I think they just pick up the standard policy. So your team can probably read through all the fine print and understand every opportunity to be able to recover. So how do you navigate working with insurance companies to ensure your clients receive fair compensation? And actually to that, and tying back to your last comment, you mentioned that people kind of don't want to sue their own insurance company as an insurance policyholder. I imagine it might be maybe either from fear, whether a misconception or not, that on your renewal, your insurance policy will go up because you did that.
Yeah, so let me address your second point first.
Okay.
I tell clients auto insurance goes up every year. You get into an accident, it goes up. You report a claim, it goes up.
Right.
Nothing happens, it goes up. Ultimately, in America, you can pick a different auto insurance company if you want, right? Free market, capitalism, yay. So that's the remedy in case if, hey, my auto insurance is going up. I've seen it too, where you can say to, speak to the agent or whoever, hey, this went up a little much, a little too high for me. Is there anything you guys can do? Because they know that if it goes up too much, there's a chance they may lose a customer. So those are your options with respect to insurance premiums going up. Again, you're paying for uninsured or underinsured motorist coverage. Why not use it? That's what it's there for.
Exactly.
With respect to dealing with the insurance companies, which was the first part of your question, I must say, as an attorney, speaking with the adjusters, right, the representatives from most insurance companies, they're actually very pleasant people.
Okay.
They have hundreds, if not thousands of cases that they're dealing with, and it's like, I'm guessing it's just a numbers game for them. We want to give between 25 and 50,000 on this case. We're evaluating this one at 75, no more. Okay, we can give a little more if they want it on this one. Just in terms of speaking with them on the phone, they've usually been quite pleasant.
Okay.
Certain carriers, you just can't reach anyone. And that's frustrating, but it is what it is. You just have to deal with it through litigation. And if it comes to putting a jury in the box and then they give an offer, that's fine if that's the way they want to play it. But in terms of dealing with your big insurance companies that you see advertising for, they're usually quite pleasant, the adjusters and representatives that I deal with on a daily basis. They usually are pretty responsive. They get back to you, in writing if you need like a no-fault ledger breakdown and whatnot pretty quickly. So it's certainly something that the client shouldn't be dealing with. Certainly the intake team will be doing a lot of the letters of representation and maybe initial calls and no-fault applications. But as an attorney dealing with them on a daily basis, asking them for money politely, I really can't say I've had too many bad experiences. They value a case at what they value it at. Maybe you're a little below, maybe you're at the same level, maybe you're a bit high. You work it out. And that's ultimately what the process is. They want to settle cases usually. It's just a matter of for how much.
So actually, just a follow-up question on that. I have seen quite a few cases where the victim settled because they tried to deal with the insurance company on their own, and obviously they don't have the whole legal background. And so then they realized their injuries were far worse than they imagined, and there was probably more opportunity to recover. Are those kind of loss causes, like, is that already put to bed? Or is there an opportunity to open that up once again and say, no, actually, this person didn't receive a fair compensation?
In my experience, and again, I'm speaking as someone that practices primarily in New York and New Jersey,
Right.
If you've signed a contract with the insurance company for money to not sue them and to settle a case, that's it. Is there a chance you could have a lawyer look at it and try to do something and say, hey, I didn't have counsel or I didn't understand? You could certainly try. I highly doubt you'd be successful in New York or New Jersey, though. It really goes by contractual terms. Once you sign, unless if there's some evidence of fraud or something else like that, that's it.
Okay, thank you so much. That's really helpful. So this is a really interesting question because it ties into actually another mass tort lawsuit, the rideshare lawsuits, right? But this one specifically asks, how has the rise of rideshare services and advanced driver assistance technologies affected the landscape of MVA litigation? Has it affected it, and how has it affected it?
Uber and Lyft have their own unique way of litigating cases.
Okay.
I've dealt with them quite a bit. This is getting into a bunch of legal mumbo jumbo that, the client wouldn't necessarily need to be aware of during intake. But to just briefly get into it, this has been in the news for a few years now. These rideshare companies state that their drivers are not employees. They're quote unquote independent contractors in their eyes. The states have come out in all different directions in terms of whether or not that's true. What that means in practical terms is if the rideshare company, and let's just say Uber here, has a driver and it is an employee, right? In most states where the driver is an employee, there would be what's known as vicarious liability.
Okay.
That would be the employee commits a tort and the employer is responsible regardless of whether the employer entity did anything wrong, right? The employee is part of the employer.
Right.
The independent contractor defense subverts that. It states, hey, we contracted with this driver to drive, but we had nothing to do with them otherwise, so don't find us vicariously liable. In my experience, obviously there's more rideshare apps now, so there's just simply more rideshare litigation.
Right.
But in my experience dealing with Uber and Lyft specifically, these rideshare companies do not want to litigate whether or not they are an independent contractor or not. They do not want a judicial determination deciding that issue. As far as I'm aware, in the state of New York, there's no court of appeals, right? The highest court in New York State, right? It goes Supreme Court, appellate court, court of appeals, perhaps counterintuitively.
Okay.
There's been no court of appeals determination in New York State that I'm aware of as of this moment that definitively states whether or not these rideshare drivers are employees or independent contractors. In other states, that may or may not be the case. Again, check the state. But this actually presents an interesting opportunity for litigants because what Uber and Lyft like to do is to try to settle pre-suit, or if you filed suit against them, pre-answer. So they may be willing to give you a decent chunk of change to just say, listen, we don't want anything to do with this. We don't want to litigate this. We believe that our driver is an independent contractor who would not be held liable, but we're willing to give you some money to make this go away. Okay. So in some ways, this is beneficial to plaintiffs and to litigants.
Interesting.
There are some downsides too, just because obviously these rideshare companies have deep pockets. You may be more inclined to try to keep them in and litigate if the offending driver, the tortious driver, has, as we discussed before, a minimum insurance policy. But ultimately, you need to be aware that there's the chance that the rideshare company could escape liability entirely using the independent contractor defense. So just to sum, I think it's a good thing. You can certainly recover more money than if it was just Joe Schmo driving or even a taxi driver necessarily, right? They may have 100,000 policy. That's common in New York. The taxis have 100,000 policy, whereas against Uber and Lyft, you can get that much or more. So these are the things you need to be aware of when suing these rideshare companies and dealing with them.
Very interesting. Thank you. Perfect. Can you walk us through the key legal considerations and strategies you use to build a strong MVA case? So part of your process, I guess?
Yeah, there's a few things. First is obviously when you do the intake, when you get the lead, ideally you try to do a good investigation. If the client doesn't have any video or pictures of the scene, there may be stores nearby that do. You never know if there's some cameras that depict the intersection or what have you.
Okay.
Maybe a witness. The second thing is in motor vehicle accident cases, there's usually, not always, but a lot of the time, there's pretty clear liability. Hit in the rear, reversed into, sideswipe, or you could be just a passenger in the car and two cars crash. I like to move for partial summary judgment as to liability as soon as possible. What that means, and again, this is specific to New York State, is you file a motion with the court, you get an affidavit or an affirmation now from the client that states, I was an innocent passenger or I was hit in the rear. You just kind of explain the basics of what happened. You submit that to the court and you ask the court to determine the other car is responsible at least 1% as a matter of law. Assuming you could win that motion in New York State, that starts pre-judgment interest running at 9%. So now, if a case lasts 2, 3, 4, 5 years, the pre-judgment interest continues to accrue, which is a very potent force in terms of settlement and going to trial. And even if perhaps you go to trial and you don't get quite as much as you'd like, now you have years of pre-judgment interest that you can tack on to the ultimate judgment.
That's fascinating. Just a side question. I imagine that the cases where the other driver at fault for reversing, those are a little bit trickier, right? Because generally it's, if you are hit in the front, it's really hard to prove that you weren't progressing versus the other person was coming backwards, correct?
So I have one that's just like how you described it. My client says that they reversed into her. They're saying she hit her in the rear. She's saying they reversed into her. So it's a he said, she said.
Okay.
Having said that, I've also had cases where my clients park and someone just reverses into them. Obviously, nowadays, lots of modern cars have backup cameras, but not all cars on the road do. I would certainly make the motion in that instance anyway, for two reasons. One, you get to see what their defense is if they're claiming, like in that case I had that I just described for you, oh, they're saying my client hit into them. They didn't reverse. At least now I know what their position is at the time of depositions and whatnot.
Right.
The second is just to kind of suss out, okay, this is how they're going to litigate the case. Maybe you get an affidavit or a declaration or an affirmation from their driver that you can use at their deposition a year or two down the line, and maybe they can't remember exactly what they put in that written document. That can be used to trip them up.
Very interesting. Excellent. So I'm going to skip to a particularly interesting question and then move backwards again. Can you share a transformative MVA case that had a significant impact on your clients or the whole industry as a whole?
I wouldn't say it had an impact on the industry as a whole simply because we settled out of court, but we were talking about rideshare companies before. In New York State, there's a 3-year statute of limitations. I had a case that hit me right around the statute of limitations. It seemed like it was pretty straightforward. My client was on a bicycle going down Broadway in Lower Manhattan, and he was hit by an offending tortious vehicle. For whatever reason, but it didn't hit my desk until almost by the statute of limitations, and that was when I deposed the defendant driver, who revealed he was utilizing the rideshare app at the time of the incident. We were able to bring in that rideshare company even though the statute of limitations had expired. And ultimately, because we were able to get the rideshare company in and settle with them, we ended up getting much closer to the true value, if not the true value of my client's case. He had had 2 elbow surgeries.
Wow.
Whereas even if we settled for the full policy against the offending vehicle, it really wouldn't have been sufficient to properly compensate him for what happened. So that's a particular case that I'm proud of that I've dealt with this year.
That is very powerful. And not just powerful, but I think you worked against all odds. I mean, you had everything working against you in that case.
Thank you. You got to just zealously advocate for the client. That's all you can do.
Yeah, absolutely. So I firmly believe that MVAs particularly, it's not black and white. It is all in the gray. And that's why I wholeheartedly agree with your first recommendation, which is go to the attorney immediately, because there is so much space to interpret the law, to find opportunities to recover. Even if the law is working against you, given the facts, you could push against it and get courts to understand the situation. So bravo to you. That's really impressive. This is interesting. So, we know that the laws are constantly changing. In what ways have changes to traffic laws and regulations influenced your approach to MVA cases over the years that you've been practicing, yours and then also your firm?
That's a tough question, just because I don't feel that in my career, and I've been an attorney now for a little over 7 years, I don't feel that the law has necessarily changed that much, the substantive law.
Okay.
With one exception. In New York State, we spoke a bit before about moving for partial summary judgment as to liability, right? Finding that the other car or the other tortious entity or whomever it may be is responsible, at least to some extent, as a matter of law. In 2018, the highest court in New York State, the Court of Appeals, ruled 4-3 that to establish partial summary judgment as to liability against an offending vehicle, the plaintiff, the movant, does not need to show that they are free from comparative fault. So even if you have a case where it might be 40% liability on your client or 60% liability on your client, in New York State, you can still move for partial summary judgment as to liability and win and start the prejudgment interest running. And we spoke a bit about this on one case I had. I have a client who was stopped at a stop sign. She looked left, she looked right, she didn't see anything. She proceeded through the intersection and she got hit.
Right.
The offending vehicle claimed that, well, she had the stop sign, she should have looked before she went.
She stopped, right?
And I deposed this young 19 years old at the time of the incident. And there was some testimony that came out that was very favorable to us. They moved for summary judgment saying our client was entirely at fault for moving, through the intersection without seeing what I would consider to be the offending vehicle, the defendant vehicle, the tortious vehicle. I cross-moved for partial summary judgment, stating, hey, he testified at his deposition that he didn't see my client's vehicle at the intersection because of parked cars, and he had what's a certain app that immediately notifies family and friends if someone's been in an accident due to the impact force and the speed. And because of that app alerting his group, he must have been going faster than the speed limit, which in New York City in most places was 25 miles an hour. Because I cross-moved for summary judgment as to liability, knowing I just needed to get 1% as a matter of law, I feel like I successfully convinced them to withdraw their motion. And they did withdraw their motion, and we're currently in the process of discussing settlement. I don't think that they were expecting that cross motion, but I was certainly within my right to do it. And, I potentially could have won on that. So we're going to try to just get that one settled.
They exhausted every opportunity for this plaintiff. Wonderful, thank you. And then our final question will be, what advice would you give to up-and-coming lawyers who are interested in specializing in motor vehicle accident claims?
Just be aware of a few things. One, to be a motor vehicle accident attorney is to be one of thousands and thousands. It's not some super specialized niche. There's lots of competition. Even just being an average or above average attorney ultimately doesn't mean that much because there's just so many attorneys doing this. You want to be in a place where you're in a firm that you like the culture of, you're working hours that you're comfortable doing, and you're making money, that's sufficient for you. It's not enough to just say, hey, I want to be a motor vehicle accident attorney, because frankly, you'd be surprised. I know attorneys that mainly specialize in family law, and they do personal injury on the side. And it's very common that most firms nowadays have some type of personal injury motor vehicle accident just because of how widespread these are. So just be aware, you may love doing this, but there's other areas of law that you can look into too. A lot of the times when you're doing motor vehicle accident, you'll also be doing premises cases or mass torts or intentional torts. So just don't try to get too narrowed into that one particular field. You can certainly practice it and be good at it, but don't think, I'm going to be an MVA attorney and that's what I'm doing for the next 40 years of my career.
Yeah, exactly.
You want to be able to branch out and do other stuff too.
Well, Philip, thank you so much for this time. This has been fascinating. I think we've all learned so much from you. As an agency that specializes in legal marketing, I'm sure for plaintiffs and victims that are looking for help on their cases, and of course for attorneys that are already practicing and at the cusp of the changing laws, and also up and coming attorneys. So thank you again. I loved speaking with you and look forward to hearing from you again in the future.
My pleasure. Anytime. Thank you.